Right, so there you have it. Two very important judgments, by the way, being delivered by the Constitutional Court in the last hour or so. Perhaps I'll start with the latest one we've just heard from Justice Matopo, who has just given the reasons behind their decision back in July, you might remember, where the MK party was essentially denied direct access. They had challenged the president's three related decisions to place Senzo Mchunu on a leave of absence, to appoint Firoz Cachalia as the minister, and also to establish the Madlanga Commission of Inquiry. We had heard in July already that the case was dismissed, but today we're getting the reasons, and this is important for jurisprudence potentially, and just understanding the thinking, the legal principles, for example, undertaken by the Constitutional Court. And in brief, the court found that the founding affidavit submitted by the MK party was quote-unquote scant and devoid of evidence, which is quite scathing if you ask me. They've also said that the Constitutional Court will only grant direct access in exceptional circumstances, and they certainly aren't convinced that this is a case in point. What they've also pointed out, which I think is quite interesting, is this idea that the matters that were raised were not necessarily, in fact, were novelty matters, and in fact they would need the assistance of lower courts, they say, in order to reach some kind of outcome. They've also mentioned, of course, that even though the issues relate or raised by the MK party have to do with the Constitution, and we know the apex court must have a final say on that, they believe that there is enough relief insofar as the law is concerned for the high courts to ventilate these issues first before, in fact, that they ultimately reach the apex court. In fact, there's a direct quote here. They say the more complex an issue is, the more assistance the Constitutional Court would need before arriving to their own findings. So essentially, if the MK party really wants to see this through, they do have the option of still going to the High Court and going through those different steps before it lands up in the Constitutional Court, even if they are right. And on that point, in fact, the court did not hit the MK party with a cost order, even though it's dismissed their case, because the apex court believes there may, in fact, be merit in some of the questions that they're raising, which is around whether or not, for example, President Cyril Ramaphosa was irrational in that decision that he's made, even though he was exercising his power. So very interesting matters indeed that are being ventilated there, and ones which we'll watch very closely. But before that, there was another important matter that the apex court had dealt with, which I think has kind of fallen through the cracks, and it was whether or not parents should be allowed equal amounts of leave. It's a major development, actually. The Constitutional Court finding that, in fact, parents, regardless of their sex, gender, race, you name it, should be allowed equal amounts of parental leave, which is, I think, 4 months and a couple of weeks. So I imagine there's going to be a lot of reaction to that. Fathers and mothers, in a heteronormative sense, can now take the same amount of parental leave, which is a new finding, groundbreaking in some respects, from the Constitutional Court. Canny Maphanga is our reporter who's been listening into both those judgments from inside the Constitutional Court, and she joins us now live. And Canny, these are two very important developments that we've just heard of, one around parental leave, and the second issue, of course, being around the reasons why the MK party's bid to get direct access was dismissed.
Indeed. Good morning to you, Ayanda, and to the viewers at home. Of course, there was another landmark decision by the Constitutional Court with respect to the rights pertaining to parental leave. We are seeing that now both parents will not be marginalized regarding this equal leave that is afforded, that is 4 months and 10 days. That means that fathers and mothers can now share that 4 months and 10 days should they choose to do so. And Parliament has been given the time to remedy that defect. We'll give you more of that judgment later on today. However, the most important matter that is being highlighted at the Constitutional Court today is affording the MK party and former President Jacob Zuma the reasons behind why their direct access application was turned away by the Constitutional Court in July, when they attempted to challenge President Cyril Ramaphosa's three related decisions regarding the Police Minister Senzo Mchunu being placed on a leave of absence, the subsequent appointment of Prof. Firoz Cachalia, Cachalia, and then the establishment of the Commission of Inquiry, which is now known as the Madlanga Commission. At the time, because of the time frame that was given, the Constitutional Court had to give an order the next day to the parties to deal with this particular application, which was that they failed to engage the court's exclusive jurisdiction. The court did not go into the merits today as to why they felt that the merits that were raised by the parties, they stating that it was not appropriate, rather that the High Court should deal with these issues first before the Constitutional Court can deal with such a novel matter. So essentially what you saw the Constitutional Court do is give you the reasons behind why the applicants failed to engage its exclusive jurisdiction, and that is the broad approach that they took to challenging the President's exercise of his powers. And they've reached the conclusion that when you challenge the exercise, it's different to the terms of him fulfilling his constitutional obligations. And of course, because of the novelty of such issues, they would have to go to the High Court first for review proceedings before it could ever reach the Constitutional Court. And we know that the MK party has already done such, and they were turned away from the urgent court for lack of urgency on this particular issue. But to join us more on how they'll take the matter forward, I am joined by the MK party spokesperson, that is Nhlamulo Ndlela, who was listening into the judgment. We know that you've already turned to the High Court, as the court has determined, and they've stated that this is a matter that should have proceeded there. They've also acknowledged the fact that you were raising constitutional issues, and they haven't hit you with costs because of that, so Biowatch does apply. But they have acknowledged that they're not going to get into the merits because this is a novel issue that should have started at the High Court first. We know that you did turn there to the urgent court, and again you were turned away for lack of urgency. So what's next for the MK party regarding this issue?
No, let me just start by saying that this is nothing more than the Constitutional Court passing the buck more than anything else. And this judgment is on the basis of an order, not on the merits of the case. I mean, they've just confirmed that it's not like this is not a meritless case. That alone should tell you that there's something substantial, and we, MK, in terms of our papers and our submissions, are onto something, that the announcement by the President ought to actually be rendered invalid and unconstitutional, because this is exactly what the case is about. The issue of direct access, this court has heard even lesser issues. I mean, lesser matters such as when the President was brought here and he was incarcerated by the same court. I mean, that's a lesser issue than this particular matter that we're raising on the issue of constitutionality. So the court, in terms of its application, we found that during the Zuma administration, the courts were able to hold the executive accountable. But what's interesting with this administration is that this court never holds, all the courts never hold the executive accountable. And we're seeing more of scapegoatism. I mean, Mkhonto Wesizwe has never lost any case, let's be clear. Everything is based on technicalities. All the merits that have been submitted have never been really presented in terms of the High Court. The High Court just based their decision on the issue of urgency, not the merits, again, which also is confirmed today that it's not a meritless case. Remember, Judge Matopo at one point during those deliberations in this court, he himself stated that the President may have erred in terms of his announcements and some of the decisions that he has taken. So that alone, by a justice in this court saying that, demonstrates, and then for them to come back today and say it's not a meritless case, is a clear indication that there is something to be heard here. And now South Africans are having to fit the bill for a commission of inquiry just for political patronage. What's also interesting, and I think we need to highlight this to South Africans, is if you see the role players in the Madlanga Commission, you can't have a judge that's going to preside over an investigation against his own peers. It didn't have to be a judicial commission of inquiry, especially knowing very well that the judiciary is complicit and found to be involved in the allegations that were brought by Lieutenant General Mkhwanazi. Now, here's something to also cite. You'll remember that, look at Marikana. It's the same president that instructed the police, using them as his private security, to go and massacre and kill those mine workers, right? Which led to the Marikana Commission. Now, what's interesting about the Marikana Commission, who was the chief evidence leader there? The same Madlanga was the chief evidence leader. Who was supporting him? Charles Kinson was under him. Who was the commissioner representing the police? Sesi Baloy. So the same players. Now what you find today is the same president now instructs the police to go and use them as a security company of his own against the issues relating to the Richards Bay minerals, the mining company. Same situation. Who was there? Again, he sends the police. Now, we're saying that, this is nothing but a farce. It's a political circus. Now you're finding Madlanga having to engage with his former colleague in the Madlanga Commission, as an evidence leader today. Now you're finding the person who was the evidence leader in the form of Mutao. He's also now stepped down. Why? Because of issues of public purse money being abused, and he sees it. There's further delays now. Why would Sesi Baloy, in actual fact, take a break and participate in the JSC? Remember, the JSC is the one that's also supposed to hold judges accountable. So she's playing dual roles, which is effectively, to an extent, has to hold herself accountable and her other colleagues accountable. But they knew that the JSC is going to happen. Why did they appoint an advocate in this case that was going to participate in this, knowing very well that she's also part of the JSC? So everything about this is just a complete farce. It's a house of cards more than anything else.
You do seem like, as the MK party, you are not happy with the outcomes of this judgment. But going ahead, are you still going to approach the High Court then and try and ventilate all of these issues that you're speaking about?
And just to add to that, Nhlamulo, the Constitutional Court is saying that this is a complex issue that must start in those review proceedings. So there has been some form of guidance in these reasons that are provided by the judgments of the Constitutional Court. It hasn't even gone into the merits. This directly deals with your direct access application, stating that it did not engage the court's exclusive jurisdiction and why. So from receiving that information, what is next for the MK? Are you still pursuing the constitutional challenge outside of the urgent proceedings, taking into consideration that this may be proceedings that you must pursue under a review?
Well, remember, this matter is now with the High Court, lower court. So it is again, kicked out on the basis of urgency. Yes. But it doesn't mean that we're not going to pursue it. We will pursue this matter until the courts and the judges have no excuse anymore, until they hear the merits and until those merits and the shenanigans that are happening in this country are exposed to the public. So we'll pursue this matter until it's closed.
All right, thank you very much. That was the MK spokesperson, Nhlamulo Ndlela, giving us the way forward after the Constitutional Court has essentially given them the reasons behind why they did not engage the Constitutional Court's exclusive jurisdiction. They, of course, have been spared from costs because the court recognizes that they were raising important constitutional matters. So the Biowatch principle does apply with this particular matter. And we know that when they headed to the Gauteng High Court in Pretoria, that is the urgent court, they failed to convince the court that it was an urgent matter, and as a result it was struck from the roll for a lack of urgency. However, now that the court, this apex court, has identified that this is more appropriate to deal with in the review proceedings afforded in the High Court, it does not stop the MKP and the former president from approaching that particular method to challenge the legality of the president's three related decisions, that is insofar as how he exercised his constitutional powers. It now remains to be seen whether the MKP and former President Zuma will follow that particular option, or will they let this case rest. Over to you in studio.
All right, Canny Maphanga, for that reaction. Thanks very much indeed. Two important matters coming from the Constitutional Court, one being the reasons behind their order back in July to deny direct access to the MK party. The second important ruling is what we're beaming to you on the side of your screen there, breaking news around this landmark judgment, essentially allowing both parents to have an equal share of parental leave. The Constitutional Court finding that that 4 months, 10 days can be in fact split amongst these parents, regardless of their gender, sex, race, and any other circumstances. It's found that sections of the Basic Conditions of Employment Act were in fact unconstitutional, and in fact Parliament has now been given a timeline to make the necessary arrangements, or adjustments I should say, to rectify that defect. So really important development indeed, and more reaction throughout the course of the day.